Get ready. 3 seconds. 2 seconds. Start. This appeal is against the judgment and order dated 2011-2001 passed by the learned session judge Jorhat in session case number 54 of 1998, convicting the appellants under section 302-34 IPC and sentencing them to undergo imprisonment for life and to pay a fine of rupees 1000 each in default of payment of fine to undergo further rigorous imprisonment for 3 months. We have heard learned senior advocate for the appellants and learned additional public prosecutor Assam for the respondent. The two appellants before us are the wife and maternal nephew respectively of the deceased, who was serving as upper division assistant in the office of the deputy inspector of schools. The investigation of the case was set in motion by the appellant number 1, a school teacher and wife of the deceased. She lodged a written report (FIR EXT2) before the officer in charge police outpost under Jorhat police station, stating inter alia that while she was in her house along with her husband, on hearing some knock at the door, she opened the door, whereupon 3 unknown miscreants entered into the house and, keeping her in the drawing room at the point of pistol, 2 miscreants entered the bedroom and killed her husband, and thereafter came out with her youngest son and left the place. When she raised alarm, her nephew came out and, on her insistence, he brought back her son from the road. Thereafter, on entering into the bedroom, they found the deceased lying on the bed with his neck tied with rope and injury on his chest. The deceased was taken to Jorhat Civil Hospital, where he was declared dead. The doctor opined that the cause of death is asphyxia following strangulation. Strangulation was caused with a rope, and the injury on the chest of the deceased was caused with sharp pointed weapon like dagger, etc. The investigating agency entertained doubt about the story of unknown miscreants entering the house at dead of night, killing the deceased and leaving the place along with the minor son without any apparent reason. The accused appellants were interrogated. During interrogation, appellant number 2, a young man of 23 years, confessed his guilt before the police of having killed the deceased with the help of appellant number 1. Stop.